Hello, everyone. Welcome to today's webinar, co-hosted by KCAB International and Arnold and Porter. 웨비나를 본격적으로 시작하기 전에 본 웨비나 진행에 관련해서 몇 가지 사항 안내해 드리겠습니다. 우선 본 웨비나는 영어로 진행되고 한국어 동시 통역이 제공될 예정입니다. 한국어 통역이 필요하신 분은 화면 하단에 지구본 모양 아이콘을 클릭하시고 코리안 버튼을 클릭하시면 됩니다. Before we begin, I would like to talk about some housekeeping matters for your convenience. First and foremost, this webinar will be conducted in English, and simultaneous translation from English to Korean will be provided throughout the webinar. Those who need Korean translation, please go to the bottom of the Zoom screen and click the button that has the shape of a globe. Secondly, there will be a Q&A session at the end of the seminar. Those who want to throw questions, please send us your questions after clicking a Q&A button, which can also be found at the bottom of the Zoom screen. With that said, let me briefly introduce myself to you. My name is Taehee, and I'm a counsel at KCAB International, managing arbitration cases. It is my honor to serve you as an MC for today's webinar. I believe for most of you, it is still within working hours. In that regard, we truly appreciate your taking time and joining us today. Today's webinar is the 13th of the KCAB International and Friends webinar series. Today's friend of KCAB International, Arnold and Porter, having its offices all around the globe, including in Seoul, has its abundant experience on today's topics, which will have particular relevance to Korean and East Asian companies. On behalf of KCAB International, I would like to convey our great pleasure to collaborate with such a distinguished law firm, Arnold and Porter, for today's webinar. I also extend our gratitude to the sponsors of today's event, Seoul RDRC, Korea In-House Counsel Association, and In-House Counsel Forum for their wonderful support. Now I would like to introduce our moderator for today's discussions, Mr. Junhee Kim. Mr. Kim is a partner at Arnold and Porter Seoul office and focuses his practice on providing counsel in international arbitration space in a variety of sectors, including but not limited to construction, intellectual property, shipping, and disputes related to joint venture and post-M&A transactions. He has represented clients in Asia, Europe, North America, and Latin America in variety of arbitral fora, including the KCAB, ICC, ICSID, SEAC, to name a few. Mr. Kim is a registered foreign legal consultant in Korea. He is admitted to the District of Columbia Bar in the United States, and also to the United States Court of International Trade and the United States Court of Appeals for the Federal Circuit. I believe his vast range of experience in international arbitration makes him the right person for moderating today's webinar, which will deal with relevant issues in various fields of arbitration. Now, without further ado, I will give the floor to Mr. Kim. Mr. Kim, please.
Thank you very much, Mr. An, and thank you for the KCAB for hosting and organizing this event. From my experience, when I'm asked about Arnold and Porter in the U.S., I think the most frequent answer I get is that it's one of the quintessential Washington D.C. firms. I don't think it'd be an exaggeration to say that if you're asked about to name one or two DC firms, that Arnold and Porter would be one of them. It's certainly one of the oldest and largest firms based in DC. But when I ask that same question in Korea, I think the reaction is usually, Arnold and Porter, that's the DC firm that is very well known for government relations, or U.S. federal work with U.S. federal agencies and U.S. litigation. And while it is true that those are very strong areas of our firm's practice, I think what people frequently don't realize is that the firm actually has one of the oldest and largest Korea practices of any international law firm out there. So for example, as far back as the 1980s, when US and Korea and US and China were involved with what is essentially international trade wars, Arnold and Porter was one of the leading firms representing Korean clients before the US government and before the WTO and whatnot. In addition to the areas that I mentioned, international arbitration happens to be one of the strong practice areas of our firm. And in fact, what people also don't frequently know is that the first ISD case that was brought against Korea in the 1980s was handled by Arnold and Porter, where we represented the Korean government. And as many of you might know, Arnold and Porter is also counsel for Korea in the largest ISD case against Korea that is currently pending. So in the area of arbitration, which is our topic today, I don't think it's an understatement to say that we're probably best known for our work in ISD, investor state disputes. But having said that, we're also very actively involved in commercial arbitration. And we also have a very keen interest in construction arbitration. So for example, William Godwin QC today will be covering construction, but it is also a key area of my practice, as well as David Reed, who is speaking today from London on the ICC rules. As far as today's topics are concerned, we had considered focusing on maybe one or two topics and going into that in a lot of depth. But I think what we've decided to do is focus on a wider variety of topics that we thought would be of the most interest and timeliness to the audience that we're speaking with today. So hopefully you'll find the topics that are interesting. And what that also means is that for the Q&A, you should feel free to ask pretty much any topic relating to international arbitration. There's no topic that's going to be off limits, and you can certainly type in your questions in Korean or English, whatever you're more comfortable with. And finally, 10 minutes for each of these topics is actually quite tight. But I think for many of the in-house counsels who are present here today, I'm sure you have many experiences having to provide a very substantive report to management within 2 or 3 minutes. So I think 10 minutes will be sufficient time for our excellent speakers today. Okay, well, with that introduction, I will introduce our first speaker, Mallory Silberman. There we go. So Mallory is joining us from our Washington, DC office, where it is currently 3 a.m. in the morning. And when we invited Mallory to speak, I was very concerned whether she could actually make it. And her first reaction, which came very quickly, was simply, let me check my calendar for that specific day. So that gives you an idea of how busy and how dedicated she is. I think she had just mentioned that you had recently wrapped up a hearing where the time zones were not that different from right now. So again, thank you for joining us. And she'll be covering investor state disputes. I should say, in terms of this practice, Arnold and Porter has had 50 consecutive positive results for sovereign states. That's 50. That's 20 years of cases, and I think that's a streak. I've not heard of anything similar to that in the area of arbitration. And Mallory has done over 40 cases for investor state disputes, and she's a true expert in this area. She also teaches this subject at Georgetown University Law School, and she's also the head of the International Dispute Resolution Committee of the DC Bar. And she's also counsel for Korea and what is currently the largest ICSID case that involves Korea. So with that introduction, I look forward to Professor Silberman's discussion on what are hot topics in ISD disputes today. Thank you.
Thank you, Junhee, for that very kind introduction, and also to the KCAB for organizing this event. And even though I can't see your faces, I did see quite a number of familiar names on the participant list. And I just wanted to say that I'm very much looking forward to seeing you all in person again soon. It's been a few years now since I've been to Seoul, and the world has changed so much since then, both the world at large and the world of investor-state dispute settlement. Within the latter world, there have been so many calls for big sweeping changes. There are voices that are clamoring for the end of investor-state arbitration, and there are also large working groups that are working to reform it. They're amending the rules, introducing and considering new soft law instruments, and debating many other types of changes. On top of that, new treaties are being negotiated, and commentators and observers keep fretting that there's just so much uncertainty. But from where I sit within the system, I don't think there's that much cause for concern, because there are a lot of things that do seem predictable. So instead of fretting over uncertainty, I figured that I would talk about the 10 things that do seem clear. So here are some predictions about ISDS. First of all, ISDS is going to survive. I can't predict what's going to happen to investor-state arbitration as such, but it does seem that in some form or another, investor-state dispute settlement will continue. Second, the parties, decision makers, and counsel will all in the future and very near future have the benefit of much more detailed norms. And by norms, I mean more detailed procedural rules, more detailed soft law, and also more detailed applicable legal standards. Now, third, even though the intention of these details is to bring about more clarity, there still is certainly going to be litigation over the meaning of these new norms. Just as in the past, there will be questions that emerge from various points that seemed clear to the drafters, and it likely will take some time for the adjudicators and counsel to get used to any new rules or new systems. But never fear, because fourth, just as always has happened in investor-state dispute settlement, the issues that are controversial one day will continue to find solutions quite quickly. And similarly, fifth, the conclusions that seem groundbreaking one day will go on to become commonplace pretty soon. And I've seen this happen time and again over the years. There would be an idea or concept that we argued for the first time and really struggled to find a way to articulate because we didn't have a model to use. We were relying on pure logic. And very quickly that became so commonplace, so well accepted, that people would forget that there had even been a question in the first place. We've seen this start to move faster and faster over the years, and I think it will become more prevalent. Sixth, there is no doubt in my mind that there will be cases that involve the COVID-19 pandemic, whether directly or just as a backdrop. Since its inception in the 1960s, investor-state dispute settlement has seen some of the world's biggest hot button issues. It has dealt with cases that were front page news, and there's no reason to expect that anything will be any different with the current pandemic. But seventh, the parties in these cases that involve the pandemic, whether directly or just as a backdrop, they won't be reinventing the wheel. Instead, they're most likely to draw on the very same principles that many previous parties have done when dealing with such issues, for example, as the Argentine financial crisis and the Arab Spring. Investor-state dispute settlement is built to handle cases such as these. Eighth, technology will continue to surprise and impress us. If you had asked me 2 years ago whether I thought I could do a hearing alone in a room from my home, I would have been shocked that you even asked that question. It would have been so unthinkable. But now that I have done 4 of those hearings, including with witnesses and experts, including with translation, including with team members and arbitrators and parties and counsel all over the world, it's not that shocking anymore. It's a brand new normal. It's pretty amazing what we can do. So technology will continue to surprise and impress us. Now, 9th, and especially importantly, I think we'll continue to see an increase in cases that involve 1 or more parties from Asia. Now, as you may know, many Asian sovereigns have been ICSID member states since the 1960s and 70s. I'm going to put up on the screen a diagram that I created, which is a time lapse that shows when sovereigns became ICSID member states. There's been a slow increase over time, and now there are quite a few member states. And many of those states and Asian parties have been involved in major milestone cases at ICSID. Junhee already mentioned the Colt Industries versus Korea case in the 1980s, which was the Korean government's first ISD case. And notably, the first known bilateral investment treaty arbitration was a case in the 1990s that involved AAPL versus Sri Lanka. This is a huge milestone, and Asian parties have been at ICSID since the very beginning. For many years, though, there were only 1 or 2 ICSID cases that involved a party from Asia. So here's another slide that shows the nationalities of the different parties over time. Cumulatively, you'll see the nationalities, or cumulatively, you'll see all of the cases. The darker blue represents the respondent, and the green represents the claimant. These figures slowly go up over time, and they've started to increase within the past 2 decades much more rapidly. I expect that this will continue as well. Now, 10th and finally on my list of predictions is something that is both a prediction and a hope, which is that we'll see more investor state arbitrators from Asia. So in 2014, ICSID released a study that showed the number of arbitrators from each state in a special report on Asia. And these were the cumulative numbers of arbitrator appointments that had gone to each state. These numbers have gone up over time, slowly, and quickly, much more recently, but the numbers are still fairly low. And I think that in the future, we can and should do better. These numbers will go up, I think, as there are more cases involving Asian parties, given all of the experience that there is in Asia, in investor state arbitration and in arbitration more broadly, and given the number of parties that are participating in this, this form of dispute settlement. So by way of brief conclusion, I think that although there is so much uncertainty in the world at large and in the world of investor state arbitration, this really is nothing new. The system was built to endure. It was built to deal with massive global events that change the world. And it was built to deal with big cases. Even though there have been calls for reform, the system is going to continue in some form or another, and it's going to be one that we all should watch in the future. Junhee, with that, I will turn things back over to you. I think you're muted.
It's quite amazing to see the number of cases that involving Asian parties that you just pulled up, not only for the number of states involved in those cases, but the number of cases in which Asian parties were investors. So that's a very interesting statistics. Thank you very much. I think we'll now turn to our next speaker, and we'll save the questions and come back at the very end. So our next speaker is Maria Chedid. Maria is joining us from well, she's based in our office in San Francisco, where she is joining us today. I believe it's a bit past midnight, not quite as bad as 3 a.m. in the morning. Maria heads our West Coast practice within the firm for international arbitration. She's currently serving her second term as the U.S. representative to the ICC court. As you know, the ICC court is the governing body of the ICC. She also has a very long and extensive experience representing Korean parties, and we are in fact working on a commercial case involving of 2 commercial cases for a Korean party at the moment. And in particular, she does a lot of work for Korean parties in the area of technical and IP disputes, and she's a frequent author on that subject. And like Mallory, she also lectures on arbitration a good amount. She's taught at Stanford, Columbia, and Berkeley, to name a few places. And in addition to English and speaking French, she's actually a native speaker of Arabic, and she has extensive experience dealing with disputes in the Middle East. And as I recall, she's actually born in the Middle East. So with that background, for purposes of today, her discussion will focus on arbitration and in the U.S. and hopefully things have become a bit more interesting in this area in the post-Trump era. So I'll turn it over to Maria. Thanks.
Thank you, Taehee, for that very nice introduction, and to KCAB for hosting this webinar. And warm greetings to all of our participants today. It's a pleasure to be with you and to provide an update on recent trends and developments in international commercial arbitration in the United States. By way of a general overview, as a longtime leading jurisdiction in arbitration, the U.S. continues to offer a favorable environment for international commercial arbitration. Since the 1970s, the U.S. has been very much in favor of use of commercial arbitration, both as a matter of congressional policy and in its treatment in our courts. It was in 1970 that the U.S. ratified the New York Convention on Enforcement of Arbitral Awards and amended the U.S. Federal Arbitration Act to implement the convention. We have an extensive case law that is very supportive of international arbitration in respect of both compelling arbitration where the parties have so agreed and in enforcing awards. The magnitude of recent cases is too profuse for me to comment on comprehensively in the short time we have. But I will briefly cover 3 issues that might be of particular interest and that have been the subject of recent case law. And then I'll turn to 1 or 2 trends more generally. First, with the steady increase in usage of international arbitration in the US, and with a legal framework that essentially provides no ability to challenge the merits of an award, we are seeing an increase in challenges to awards based on arbitrator conflict or disclosure issues. Such challenges typically do not succeed, but I'll speak about one recent case in which a petitioner was successful in overturning an award. In that case, the reason the award was set aside is because the arbitrator had a limited ownership interest and equity interest in the arbitral institution, and the arbitrator had not disclosed that ownership interest to the parties at the outset of the case. The court found the non-disclosure material because one of the parties to the arbitration was what we call a repeat player or repeat user of the institution's arbitration services, having employed those services 97 times in the past. The court viewed the ownership interest combined with the level of repeated usage by that one party could reasonably cause concern about potential partiality, and that it therefore should have been disclosed. While acknowledging that the US legal system has a strong interest in finality in arbitration, and that judicial review of arbitration awards is therefore often unexacting, the court at the same time observed that there should nevertheless be judicial enforcement of an arbitrator's duty to disclose. The losing party in the case petitioned for review of the decision by the US Supreme Court, our highest court, but review was denied. If you're interested in learning more about this decision, the case name is Monster Energy versus City Beverages. And that case came out of the Ninth Circuit Court of Appeals. A second issue of importance, and this one our US Supreme Court has very recently agreed to hear on appeal, is whether parties to commercial arbitration proceedings outside the US can petition US courts to gather evidence relevant to their arbitration dispute from parties located inside the US. This would permit discovery that otherwise would not be available to arbitrating parties within the arbitration disclosure process. And it would include the ability to obtain documents and depositions from non-parties to the arbitration. The federal US statute at issue is Title 28, United States Code, Section 1782. The question the Supreme Court will decide is whether this statute was intended to extend to a private commercial arbitration abroad, or whether Congress intended it to be available only to aid foreign government tribunals or some other foreign state-sponsored adjudicatory body. Currently, our federal circuit courts in the US are divided on this question, so the Supreme Court is expected to provide clear guidance when it decides the matter. If you're interested in tracking this development, the case that is pending before the Supreme Court is called Servotronics versus Rolls-Royce. Moving to the issue of virtual hearings, this last year has seen the international arbitration community swiftly embracing remote hearings due to the pandemic. That has been true for arbitration in the US, as well as for litigation in the US court system. So there has generally been no serious concern from a US perspective that a party's objection to the modality of a remote hearing would pose a threat to an award issued in any such arbitration. In what is believed to be the first reported US court decision to address a challenge to holding a hearing remotely as a result of the pandemic, a US federal court in the state of Illinois rejected the party's attempt to enjoin an arbitrator from proceeding with the remote hearing. That party based its objection on the ground that a remote hearing would be too cumbersome and procedurally irregular. The court held that remote hearings are admittedly clunkier than in-person hearings, but in no way prevent parties from presenting their claims or defenses. The case is called Carlos Legaspi versus Financial Industry Regulatory Authority, or what we call FINRA, F-I-N-R-A. Given the success of remote arbitration hearings, it's anticipated in the US that they will often continue to be utilized, even after COVID-19 restrictions are no longer an issue. Next, I'd like to turn to more general trends and developments over the last couple of years in the US. One is the number of US cities investing in development and promotion of their specific jurisdiction as an attractive seat for international arbitration. Historically, it was New York, as a leading global financial center, that was the US seat most likely to be considered by international parties. But we have seen this change significantly over the past several years as San Francisco, Los Angeles, and Miami have emerged with steadily increasing numbers of arbitrations seated in those cities. In addition, Boston and Atlanta are now seeking to market themselves as desirable US venues. With respect to California in particular, the expectation is that growth in the next 5 years will be very substantial for several reasons. The first is the massive size of the California economy. As you may be aware, it is the 5th largest economy in the world, with the first 4 largest economies being the US as a whole, China, Japan, and Germany. Second, over the last 5 years, international commercial arbitration has gained wider acceptance among corporate counsel in the high-tech industry centered in California's Silicon Valley, and increased usage by California companies in the life sciences and entertainment industries as well. Third, for many years, there was uncertainty in California about whether foreign lawyers not licensed to practice in the state could appear in international arbitration seated there. In 2018, at the urging of the California international arbitration community, including myself, the California Judiciary and Legislature resolved this issue by passing a new law expressly authorizing foreign lawyers to freely represent their clients in international arbitration proceedings in the state. That law went into effect in 2019 and removed a long existing obstacle that previously had made it very challenging for California parties to negotiate arbitration clauses designating their home state as the seat. As a California practitioner, I've seen a marked change in the number of California clients who have moved away from US court forum selection clauses to international arbitration clauses in their cross-border transactions. Much of this in response to the permissive new foreign counsel law, and also as a result of educational efforts and initiatives led by Arbitration Council, arbitrators, and arbitral institutions who recognize the deep untapped potential for growth of arbitration activity in California, which notably was the first state in the US to adopt legislation based on the 1985 Unstitral model law on international commercial arbitration. With that, I've come to the end of my time, so let me stop there and thank you all for your attention. I would be happy to take some questions at the end of the program. Thank you, JH. You're on mute, JH.
Thanks very much for the very insightful presentation. As you noted, we'll turn back to questions at the very end. And I'm now very happy to introduce our next speaker. William, perhaps you can join us out. No? Yeah. William, perhaps you can turn your video on and I can introduce you.
I think it's been stopped, Junhee. Oh, yeah, here we go.
Okay.
Oh.
Yeah, we can see.
The host has stopped it, apparently.
We can see you now. It's a slightly
okay, okay, great. Okay, thank you.
Great. Okay, we can see.
Thanks.
Very good. Well, let me introduce you. So our next speaker is William Godwin, Queen's Counsel. He is based in our London office. William has a significant amount of experience representing clients, including Korean clients, before the English commercial courts. He also does a good amount of construction arbitration and arbitration for shipyards, both in Korea as well as other companies in East Asia, including China in particular. He was recently a member of the FIDIC task force that was involved in revising the FIDIC rules, the FIDIC guidelines of 2017. And that includes all of the 3 major FIDIC forums. And he's also actually the author of this book that he so kindly shared with me last year. And it's actually quite a good read. So I thank you for sending that on the 2017 FIDIC contracts. And today he'll be talking about sort of the how to prepare for some of the key issues of how to prepare for post-COVID in the area of construction. Thank you, William.
Well, thank you, Junhee. It's very kind of you to introduce me and to plug my book in such an effective manner. That was very gratifying. It's a great pleasure for me to take part in this webinar today, and I'm very grateful to KCAB for hosting and organizing this event. I'm going to talk, as Junhee mentioned, about construction disputes in particular, and preparing for the post-COVID era, if you like, or the after effects of COVID, because they're going to lead and have already started to lead to some pretty fundamental effects and changes. Can we go to the first slide, please? First of all, we've seen a huge backlog of claims in projects globally. I'm sure many of us today have experienced how the pandemic has led to severe delay and disruption to projects. Supply problems, workforce reductions, and local restrictions have all conspired to cause huge levels of delay and disruption. One prominent example is the Jakarta-Bandung high-speed rail project in Indonesia. You may have come across $6 billion project. Indonesia's first high-speed rail project was nearly 64% complete when it suffered stoppage and delays from early 2020 due to COVID-19 restrictions. And there are, of course, many other cases across all sectors. And another important respect in which we have felt the impact of COVID has been the ways in which construction disputes are managed and resolved. COVID has accelerated changes which had already begun before the pandemic, and it seems likely these will continue when it is eventually controlled. We'll look at this again shortly, but in summary, there's a twofold effect to prepare for, I think. There's, first of all, the nature and extent of claims arising from the pandemic, and then new ways of dealing with construction disputes. Could we have the next slide, please? We look at claims, first of all. Force majeure has been and will be widely invoked, often by the contractor. A force majeure clause enables the party affected to stop performing the contract while the effects of the force majeure event or circumstance last. These clauses can take different forms, but the underlying purpose is that if certain events or circumstances occur which are outside a party's control, it should be excused from performing all or part of its obligations as set out in the clause. And it's very important that last part, as set out in the clause. The clause should carefully define the events or circumstances constituting the force majeure. Such matter as war, hostilities, and civil disturbance are typically listed, as well as natural catastrophes like earthquakes and floods. In the FIDIC contracts, interestingly, in both editions, the 1999 and 2017 editions, pandemics are not specifically listed, although they could constitute force majeure events because the FIDIC list is stated not to be exhaustive. It's something that can be added to so that something or some event or circumstance might be a force majeure, even if not specifically listed. There may and usually are other requirements in a force majeure clause apart from the events being out of the party's control. Again, in the FIDIC contracts, these include no fault on the part of either party, and also the party affected has to be shown to be unable to control or overcome the effects of the event or circumstance that constitute the force majeure. Could we have the next slide, please? If the clause applies, so that if you come within the four corners of the clause, its effect is normally suspensory. It suspends performance for the duration of the event or circumstance. And as the effects of the event or circumstance come to an end, the contract is reactivated, so to speak. But it's important to remember that quite apart from force majeure, claims to extend time due to pandemic-related circumstances are available under most contracts, and they have proliferated. One example, again, from the FIDIC forms is clause 8.4d of the 1999 edition, the red and yellow books, delay resulting from unforeseeable shortages of personnel or goods caused by epidemic or governmental actions. would justify a Clause 8 extension of time application by the contractor. So even if the pandemic effects may not, on the particular facts of the situation, count as force majeure, the contractor may be able to obtain an extension of time for those effects, or in some cases, additional payment as well. Under Clause 13.7 of the 1999 FIDIC forms, again, taking that as the leading international engineering standard form, under 13.7 of the 1999 forms, red, yellow, and silver books, if there's an increase in cost as a result of complying with changes in legislation affecting the project, the contractor can get an adjustment to the price. And similar provisions apply in the 2017 editions. So these would cover local regulations, for example, restricting work on site. And in many cases, the contract, it's important to remember, will not exclude remedies which a party might have under the general law governing the contract. Again, in the FIDIC books, this is expressly allowed for in Clause 19 of the 1999 forms and Clause 18 of the 2017 editions. So, for example, if you have a contract, a FIDIC contract governed by English law, and the pandemic effects are severe enough to, as they say, frustrate the contract or make it impossible to perform, that could be effective to end the contract and release the parties from performance. This English law doctrine of frustration, and there are counterparts in civil law systems, is most often invoked if there is no force majeure clause, or if there is a force majeure clause, the particular event or circumstance facing the party affected is not actually covered by the force majeure clause. So it's important to remember that in many contract forms, your general law rights are not affected by the presence of a force majeure clause. Could we have the next slide, please? Another important thing to bear in mind, of course, is the availability of termination of contracts in the face of these extraordinary effects of the pandemic. Terminating contracts has become much more frequent, but also, unhappily, have the problems that can result if the terminating party doesn't get it absolutely right. So the first thing to do when contemplating termination is to make sure you have a valid ground of termination. And that can be difficult, particularly where you have grounds which may not be easy to establish. And one of the reasons for that could well be the availability of different interpretations of the relevant contractual provisions. So under Clause 16.2 of the 1999 FIDIC forms, again, taking that as an example, the contractor may terminate where the employer substantially fails to perform his obligations under the contract. Whether or not the employer on the facts has substantially failed to perform his obligations under the contract could well be open to interpretations and conflicting submissions and evidential reliance. So you have to be particularly confident in those kinds of cases of your facts before you take the nuclear option of terminating the contract. Next slide, please, if we may. A red light here, if you get a termination wrong, not only could you pay substantial damages, but the other party might be able to treat your actions as itself constituting a ground of termination. And the practical lesson here is that if in doubt, ask yourself if there is anything you can do to improve the relationship first. One important thing to note is that contractual termination rights may be in addition to any other rights you have under the governing law of the contract to terminate. In an English law contract, for example, certain sufficiently serious breaches of the contract may entitle the other party to terminate lawfully, even if that conduct is not a ground of termination set out in the terms of the contract. The remedies available to the terminating party may also be broader under the general governing law than under the specific terms of the contract. So your contractual remedies, for example, to certain payments following termination, may not be the only ones, and the terminating party could be entitled to further or other remedies in accordance with the governing law. And the contract sometimes expressly preserves these entitlements. Again, clauses 15 and 16 of the FIDIC contracts is a clear example. Next slide, please. So by way of short summary, the effects of the pandemic have been devastating. Its after effects will be long lasting. In better times, contractors and employers could take a hit on a project and move on, but the deep effects of the current situation often mean claims are pursued all the way to arbitration, and therefore the emphasis is very much on awareness of contractual and other rights, and a big part of any effective strategy to avoid or reduce disputes is that kind of awareness. And that takes us into looking now at how disputes are handled. May I have the next slide, please? Just briefly. We've seen, I think, that COVID has virtually overnight led to really very significant changes in the ways in which construction and other complex disputes are resolved. Some of these changes were already on the way, but COVID has put the accelerator on tenfold to these changes. And the most obvious is the use of technology to facilitate virtual hearings, meetings with counsel, clients, and teams. You could say that these are now the norm in arbitrations, adjudications, and mediation, certainly in many people's experience. And I'm sure we've all had experience of virtual hearings and certainly meetings. This does, could we have the next slide, please? This does come potentially, this adaptation at a cost. Maria mentioned that virtual hearings, and this is certainly my experience, can often be much more clunky or less easy to manage than in-person hearings. But one significant downside, certainly in my own experience, is that if you have a dispute involving issues of credibility, particularly, where a lot depends on the tribunal's assessment of the way in which a witness responds to questions and deals generally with matters in an in-person setting, verbal and non-verbal indicators and cues will be lost in the virtual world. So that's I think not to be overlooked downside, but the reality is that either the hearing is virtual or it doesn't take place at all and is postponed indefinitely, which is, of course, itself a major detriment. But the flexibility and party autonomy which characterize international arbitration has allowed it to develop and adapt in response to the needs of users. And we've seen this particularly in the adaptations of technology. One very helpful annual survey of arbitration users, which I'm sure many of those taking part today are familiar with, has been the Queen Mary University of London and White and Case annual study of international arbitration. And this year's survey came out very recently, only on the 6th of May this year. It's highly regarded and based on extensive research. The new report, in fact, is based on the views of 1,200 users of international arbitration. And if we could go to the next slide, please. Just to wind off, forgive me, could we go back to the previous one? Sorry. Yeah, Just to wind off, the survey shows or found that adapting in response to COVID-19, 72% of arbitration users have now used virtual hearing rooms, and only 16% would postpone a hearing to hold it in person. And that's, I think, a very significant figure. Looking ahead, next slide, please now, forgive me. Respondents expressed a strong desire for more administrative and logistical support for virtual hearings to be provided by arbitral institutions. So a need for more hands-on support for the actual conduct of these hearings by the arbitral institutions themselves. Apart from arbitration, in the world of construction, dispute review boards and adjudication have, of course, long been important alternatives to arbitration in the construction industry, and the Queen Mary results show strong positive support for the continued use of adjudication and dispute review boards in resolving construction disputes. So there's a continuing support, and of course, an adjudication or a mediation is making use and adapting of to the available technology as well. Well, thank you very much for your time, and my thanks also to the interpreters. I hope I haven't gone on too long or too fast. Thank you. Junhee, over to you.
Great. Thank you very much, William. That was a lot of information done very efficiently and very much appreciated. We are falling a little bit behind time, so we'll move things along. I'll invite our next speaker, David Reed, to join us on the screen. Great. Hi, David. So I'll introduce David. David is based in our London office. He studied and practiced both in France and England, and he speaks both languages fluently. He'll be covering the ICC rules today, but his practice is very varied, including commercial arbitrations in sectors including construction, shipping, IT, energy, oil and gas, and banking. He also does investor state disputes as well. And in the area of construction, we've also recently done some work for Korean clients with legal issues outside of Korea. And I'd have to say that given his background, experience in both teaching and practicing both civil law and common law, he has a very unique background and a very unique perspective in dealing with the two different legal systems, which is very useful in transnational disputes. So today, the issue we'll be covering is the amended ICC rules. As I mentioned earlier, Maria Chedid is actually on the ICC court, and I think she would have very unique insights on how those rules were amended. But for purposes of today, I think we're going to approach it from a practitioner's perspective and also what clients might be more interested in. Take it away, David. Great.
Thanks, Junhee, and thanks to KCAB for hosting this event, and thank you all for the fantastic turnout this morning, or this afternoon in Korea. 5 months ago, in January 2021, the ICC's latest arbitration rules, the 2021 rules, came into force. And my plan this afternoon is to take you on a quick tour of the most important changes. So in my 10 minutes, I'll share with you my top 10 new features of the 2021 rules. Unlike most top 10s, these are going to be presented in no particular order. So on to number 1, Article 22.2 of the new 2021 rules. Under the rules before the beginning of this year, tribunals were encouraged but didn't have to adopt case management techniques to ensure effective case management. The new Article 22.2 of the 2021 rules replaces the word may with the word shall, so that arbitral tribunals now have a positive duty to adopt effective case management measures. They retain, of course, a discretion over what case management measures to adopt. So this change, is it a good thing? Well, in principle, yes, it is, because it encourages and indeed requires arbitral tribunals now to proactively think about how to run cases more effectively. Except there's no real consensus on how to conduct arbitrations efficiently. And sometimes, of course, in practice, attempts to streamline arbitration to make it more efficient don't always work out quite as well as intended. So there may be some learning curve issues as tribunals learn to exercise these powers, this requirement, judiciously. The second notable innovation is the power given to tribunals to impose virtual hearings. This is in a new Article 26, which empowers tribunals to decide whether to hold hearings in person or remotely. And this change to the rules is, of course, in part a response to the effects of the COVID-19 pandemic. And as has been noted by others, over the past 15 months or so, it's been difficult and sometimes impossible to hold in-person hearings. And it's turned out that video conferencing facilities such as WebEx, Zoom, Teams, and others have actually proved surprisingly effective. And there are now service providers who can create virtual hearing venues that make proceedings easier to manage. I guess time will tell the extent to which in the future most hearings will continue to be held remotely. But even after the worst of the pandemic is behind us, there will still be other considerations which will favor the continued use of remote hearings, notably cost, but also increasingly the need to fight against climate change by diminishing our carbon footprint. Virtual hearings, of course, will need to be found to satisfy the right to a fair hearing under the law of the seat and the law in the place of enforcement. And Maria commented earlier on a US case that had considered that issue, and there are other courts in other jurisdictions, such as Austria, that have also approved virtual hearings. So it seems almost inevitable, I think, that in future case management conferences and other short hearings will be conducted almost exclusively virtually. The main question mark, and William alluded to this, cases where there's extensive fact witness or expert witness evidence, in particular where the credibility of witnesses is important. But there's also the issue of distant time zones. And distant time zones can, as Mallory and indeed Maria are experiencing today, distant time zones can make virtual meetings and hearings a little more challenging. I think we're likely to see also the recourse to hybrid hearings involving some in-person participation and some virtual participation as well. I think it's likely, and William was alluding to the Queen Mary survey that seems to call for this, that the ICC will have to issue additional guidance on the conduct of virtual hearings in the future. Feature 3, the fight against climate change is driving changes to the ICC rules. The ICC rules, I've already mentioned the virtual hearing point, but the ICC rules now remove the presumption in favor of paper filings. Article 3.1 now provides for electronic communication of submissions, notifications, and communications. There's a partial exception for the request for arbitration to initiate proceedings and the answer, where the filing party can elect to use hard copy filings if they wish physical service to be affected and recorded, and they may consider that to be necessary in certain jurisdictions. It's going to be interesting to see whether a new objection based on climate change impact, carbon footprint, will now be used alongside traditional objections such as disproportionate cost, unnecessary undue burden in objecting to other procedural matters in arbitration, such as document disclosure, or the extent of document disclosure. Change number 4, and I call this one, no one's safe from a lawsuit, because as the ICC has recently found, even the ICC itself can be hauled into court by litigious parties. So to protect the ICC, a new Article 43 of the 2021 rules provides that claims against the ICC court arising out of the rules are going to be governed by French law, and the French courts will have jurisdiction. Change number 5 concerns treaty-based arbitration. As you know, some bilateral and multilateral treaties provide the option of ICC arbitration for the resolution of investor-state disputes. And a new Article 13.6 of the 2021 rules introduces an enhanced neutrality requirement in treaty-based arbitrations by barring all the arbitrators on the tribunal from holding the same nationality as any of the parties, unless the parties agree otherwise. Previously, prior to this year, that requirement only concerned sole arbitrators and chairs and didn't extend to co-arbitrators. New feature number 6, better control of conflicts of interest. Maria, I think, alluded earlier to new case law in the US on conflicts of interest. A new Article 11.7 requires the parties to disclose the identity of any third-party funders. As you'll know, professional third-party funders have, of course, been increasingly prominent in financing arbitration claims in recent years. And Article 11.7 requires them, but also any third party that provides funding and has an interest in the outcome to be disclosed. It's a requirement to disclose the existence of third-party funding to assist with the assessment of conflicts of interest. So it's only the identity of the third-party funder that has to be disclosed by reason of Article 11.7 and not the terms of the funding agreement. A recast Article 17 also requires the parties to notify promptly any changes in their representation in the arbitration, and now empowers tribunals to refuse changes in counsel or limit their participation. These rule changes reflect the realization that conflicts can arise not just in relation to parties and counsel, but also by reason of other interested parties, here third-party funders. And moreover, changes in the identities of interested parties, such as a change of counsel, over the course of an arbitration can raise fresh conflict issues, if not properly policed. And therefore, these rule changes are welcome, but they don't really go far enough, because it isn't just third-party funders and counsel changes that can raise these types of problems. For example, there are cases where the relationship between an expert witness and an arbitrator has been challenged, and the 2021 rules don't deal with disclosure and early disclosure for that purpose. Change number 7, and perhaps the most important changes, concern joinder and consolidation. It's long been pointed out, of course, that arbitration can be less effective sometimes than litigation in resolving multi-party and multi-contract disputes. Some of you may be familiar with Sir Michael Kerr's Macau sardine case story from over 35 years ago now, about the potential pitfalls of arbitrating string contracts. Since then, we've had revisions over time in the ICC and other rules to facilitate as much as possible both joinder and consolidation. And the 2021 rules introduced a couple of important additional innovations in this respect. First, a new Article 7.5 provides that a new party can be joined to ongoing proceedings, provided that the new party consents and the tribunal is satisfied that it's appropriate. So this will notably, for example, allow an affiliate to be joined as a co-claimant if, for example, in the course of the proceedings, the existing claimant realizes that some or all of the loss has been sustained by an affiliate rather than by the claimant itself. However, this will not usually allow a new respondent to be joined after the constitution of the tribunal, either by the claimant or as a result of a cross-claim by an existing respondent. Those parties can't be joined against their will after the constitution of the tribunal. And so considerable care is still required at the outset of the dispute to properly identify the necessary parties to the dispute, because if the realization only dawns later, it may be too late. 2021 rules also usefully expand the possibilities for the consolidation of disputes. Article 10b in particular now provides that the ICC court may consolidate 2 or more pending arbitrations, even if the arbitrations involve different parties under different contracts, provided the arbitration agreements are the same. And this welcome change can notably facilitate the arbitration of string contracts, to which I alluded earlier, on a consolidated basis, and possibly even if the arbitration clauses are identical, the consolidation of arbitrations between, for example, an owner and a main contractor, and a main contractor and a subcontractor and a supplier. So that's potentially a very important innovation. Innovation number 8 concerns increased transparency in the decisions of the ICC court. Under the ICC rules, certain important decisions are made by the ICC court rather than by arbitral tribunals. This includes, for example, decisions on the existence of a prima facie agreement to arbitrate, consolidation of arbitrations, appointment of arbitrators, challenge of arbitrators, and replacement of arbitrator in certain circumstances. A new Article 5 of Appendix 2 of the revised rules provides that the ICC court may communicate its reasons for its decisions in these matters. However, the request for reasons has to have been made in advance of the decision. Afterwards, it's too late, so that needs to be borne in mind. And the ICC does reserve the right to refuse to disclose its reasons in undefined exceptional circumstances. Key change number 9, additional awards as a remedy for omitted claims. The ICC rules, of course, have long made provision for the post-award correction of errors or for the interpretation of ambiguity. But a new Article 26.3 now makes provision for additional awards, post-award, to be issued if a tribunal has omitted to rule upon one or more of the claims in the arbitration, provided an application is made within 30 days. And this welcome change, which brings the ICC rules into line with other arbitration rules, helps preserve awards from infra petita challenges before state courts. Finally, number 10, which has been described as the most controversial change in the 2021 rules. A new Article 12.9 provides that in exceptional circumstances, the ICC may appoint all the members of an arbitral tribunal to avoid a significant risk of unequal treatment and unfairness that may affect the validity of the award, even if the parties' agreement provides otherwise. Now, the aim of this provision is to preserve awards from challenge in circumstances where parties' agreement itself provides for an unfair and unequal method for nominating the tribunal. This change is controversial really for 2 reasons. First, because it puts a limitation on the right of parties to nominate their own arbitrator. And second, because the circumstances in which the party's choice will be overridden under Article 12.9 are somewhat vague. Nonetheless, the provision is plainly aimed, for example, at the kinds of cases which crop up from time to time, where because of a power imbalance between the parties, one side has been given a disproportionate influence on the composition of the tribunal under the agreement to arbitrate. For example, one side gets to choose a sole arbitrator, or one side gets to choose the chair. Rather than risk such arbitrations going forward and then being challenged, or alternately, striking down the arbitration clause and causing the parties to have to go to litigation, Article 12.9 seeks to allow the arbitration to proceed, but with an independent tribunal. So these are the main changes to the new ICC rules. There are others I could have mentioned, but they're mainly relatively small, minor wording changes. I guess more significantly, the threshold for the expedited treatment of small claims has been raised from $2 million in dispute to now $3 million in dispute. And given that over 35% of ICC's caseload concerns those kind of small cases, I think the increase in threshold is to be welcome. And in fact, I think an argument could have been made to make the threshold even slightly higher. So with that, I complete my whistle-stop tour of the new 2021 rules. Thank you very much.
Thank you, David. 10 points in almost 10 minutes. That's pretty good. Thank you. Okay. Before I introduce our next speaker, I should note that there is a Q&A function on the bottom of the screen if you would like to type in questions for any of our speakers as we do the presentations. You should feel free to do so. So I'd like to be able to say that we're saving our best for last. And in this case, I actually don't think we're that far off. So Anton Ware is based in our Shanghai office. And he'll be speaking about sanctions and international arbitration today. It is in itself a very hot topic in this area. But in addition to I know the topic that he's covering is a very quite diverse practice. Along with Mallory, he's one of the counsels that's representing Korea in the largest ongoing exit case that Korea faces. Last year, he was one of the main lead counsels for a major ICC case that Lone Star brought against a Korean bank, and all of those claims were dismissed. And Anton played a major role in that case as well. Because he is based in China, in addition to commercial and investor state arbitration, he also handles a lot of inbound work for foreign clients who have legal issues in China. And I should also note that he is a fluent speaker of Chinese Mandarin. And if asked, I would not be surprised if he can do this entire presentation in Chinese as well as English. Well, with that introduction, I turn the floor over to Anton.
Thank you very much, Junhee, and thank you to KCAB for hosting this event. Thank you also to the attendees for sticking with us. I know we're past the hour at this point, so I will try to move quickly, but hopefully not too quickly for the interpreter. We're living in a world today in which the foreign policy agenda of one country, the United States, can insert itself at any moment without warning into the business dealings of any company or person anywhere in the world. I'm referring, of course, to the US government's increasingly frequent use of financial sanctions and export controls as a tool of foreign policy. As the use of these tools has increased, their impact on the legal affairs of our clients has expanded. Sanctions and export controls are no longer merely a compliance issue. More and more, they're giving rise to commercial disputes and even are beginning to interfere with the smooth functioning of ongoing arbitration proceedings. As disputes lawyers, whether in-house or external, we need to be ready for the sanctions and export control challenges and risks our clients may face. So what are some of the areas in which arbitration and sanctions intersect? The first and most important point of intersection is during the course of contract performance, before any dispute has arisen. Imagine a scenario where you have a Korean company, we'll call it Company A, that manufactures components that are used in consumer electronics products. Now, Company A has a supply contract with Company B, which is a Chinese consumer electronics company. Under the contract, Company A has an obligation to supply a certain number of components to Company B each month and is potentially liable for damages in the event that it fails to meet the required supply. Everything's going well in the relationship until suddenly one day, you wake up and read in the newspaper that an affiliate of Company B has been placed by the United States government on something called the Entity List for allegedly having participated in activities that are contrary to US national security interests. Under US law, it's a violation of export control regulations to export, re-export, or transfer US technology to a company on the Entity List without obtaining a special license from the US Department of Commerce. Now, Company A's in-house counsel reads about this development in the newspaper, and her first thought is, we have a compliance issue. The components we manufacture incorporate US-made chips. If we continue to supply our components to Company B, we might be accused by the US government of violating its export controls laws or causing or aiding or abetting a violation. And then comes the second thought. But if we stop performance under the contract, we could be accused by Company B of breach of contract and could be liable for significant damages. So the in-house lawyer rushes to pull up a copy of the relevant supply contract to see if it contains any relevant provisions that might excuse performance under these circumstances. There's a force majeure clause and an illegality clause, but nothing expressly mentioning sanctions or export controls. If Company A has to prove that it would be impossible or illegal to perform the contract, would it be able to do so? There are several potential obstacles. For example, does the US government have jurisdiction to prohibit a Korean company from doing business with a Chinese company? Does US law even apply? Another complexity is the fact that Company B itself was not placed on the Entity List. Only its affiliate was listed. And there's a question as to whether selling to Company B could run afoul of the Entity List restrictions. The Company A in-house lawyer also notices that the supply contract is governed by Chinese law. And China, as it turns out, has recently enacted a blocking statute, which is intended to prohibit companies from complying with unilateral sanctions measures imposed by other countries against the Chinese entity. If Company A refuses to perform the contract in order to comply with US law restrictions, will it be in breach of the Chinese blocking statute and potentially subject to liability under that law? You can see that our hypothetical Company A is all of a sudden facing a minefield of compliance and disputes risks. What can be done to address those risks? Well, if we could go back in time to when the supply contract was drafted, we could consider including a sanctions clause. And this is now something that we recommend to many clients for their international transactions. A good sanctions clause would include, for example, representations and warranties relating to compliance with specified sanctions and export controls regimes, notice requirements in the event either party becomes aware of actual or suspected violations of applicable sanctions laws, and a stipulation entitling either party to stop performance or terminate the contract without penalty in the event of certain triggering events in relation to actual or potential sanctions violations. Now, if we don't have a sanctions clause, all hope is not lost. Keep in mind that there are ways to seek clarification from the US government as to whether continuing your contract performance would violate US law. It's also possible to apply for a license to deal with a listed entity. And we have a dedicated team of sanctions specialists in our Washington, DC office who assist clients with obtaining such licenses. Now, there are other points of intersection between arbitration and sanctions, which I will mention very briefly. First, you might be in the midst of an ordinary commercial arbitration when one of the parties to the arbitration is added to a sanctions or export controls list. If that happens, what are the implications for the arbitration proceeding? Well, if there are US parties or US lawyers involved, it may become necessary to seek and obtain a license from the US government before the arbitration can proceed. Why is that? Because, for example, providing confidential information to the listed party in your submissions or as part of the disclosure process could itself violate the sanctions or export controls regime absent a license. At the stage when an award is issued or a settlement reached, paying damages to or even receiving payment from the listed party could be a violation absent a license. Keep in mind as well that if you're dealing with financial sanctions, any international bank transfer is likely to be frozen and may take a long time to release. A second example, what happens if one of the arbitrators is sanctioned during an ongoing arbitration proceeding? Now, many of us had not even considered this possibility until a well-known international arbitrator, current Hong Kong Secretary for Justice Teresa Chang, was sanctioned by the US government in August 2020 in relation to Hong Kong's implementation of national security legislation. If such a sanction were imposed on an arbitrator sitting on your case, any US persons involved in the case might have to immediately withdraw because it's unlawful to receive services from a sanctioned person or to pay fees of any kind to the person. Even non-US participants would be unable to pay arbitrator fees to the arbitrator through US banks or using US dollars. Third and final example, what if one of the lawyers or experts in the case is sanctioned? The same issues of payments and services arise. This possibility became very real in March of this year when China issued sanctions against Essex Court Chambers as a result of a legal opinion issued by 4 members of Chambers. Prominent arbitration practitioners immediately left the chambers, presumably to avoid continuing to associate with a sanctioned entity. And the fallout is continuing to be felt across a wide range of cases. As you can see, sanctions and export controls regimes have the potential to generate a wide variety of disputes, many of which will be subject to arbitration. Sanctions and export controls also have the potential to disrupt and interfere with ongoing arbitration proceedings in unexpected ways. The imposition of sanctions often comes without warning, which makes it all the more important for us as in-house and external lawyers to be prepared. That concludes my remarks. Thank you very much.
Thank you very much, Anton. I would now invite all of our speakers to rejoin, and we can take any questions from the audience at this point. I will start, and I think for the questions, again, you can type them in, or there's also a raise hand function. You might want to try that as well. I will start with one of the questions that we received previously, and it's a topic that we haven't covered today, but it's something that I think we had thought about, which is the potential future of London as a seat of arbitrations. It has been traditionally a very popular seat, especially with Korean parties, for a variety of good reasons, but with Brexit and other issues, including the rise of seats in Asia, including Singapore, Hong Kong, and Seoul, I think more parties are beginning to question whether London is the best place to go, or whether there are other better alternatives for a party that doesn't necessarily have a dispute that's tied with London. There have been other seminars that actually covered this specific topic, but I'd be curious as to our views, and maybe David, since you're based in London, would you like to start that one off?
Sure, thanks, Yoon-hee. I think the consensus in London so far up till now is that COVID-19 has had a bigger impact on arbitration in London over the last year or so than has had Brexit. But of course, going forward, there will be change. There's no doubt about that. I think it's likely that London will lose some arbitration business to the European continent in relation to arbitrations with a locus in the EU. But at the same time, and obviously Brexit was a hugely controversial decision, but for those in favor of it, the idea was to perhaps have a slightly less intense embrace with Europe, but a greater engagement with the rest of the world. And to the extent that that turns out to be a UK policy, it's possible that London will see new opportunities around the world. With that said, there's no doubt at all that other centers around the world have become major centers for arbitration, very much in competition with London. I think that's to be welcomed, actually. And particularly, as we were saying earlier, with the virtual hearing world, being in similar time zones is going to be a significant factor in choosing who should be the participants, I think.
Okay, great. We had another question that came in, which relates to ISD arbitration, and the question was, when selecting counsel, are there any recommendations that you would advise clients? And I think that could be broken up to depending on whether it's a state client or an investor. Mallory, would you like to take a shot at that one?
Sure. I think experience is probably the most important factor, because investor-state dispute settlement really has its own language, and it's important to have counsel who are fluent in that language, and on top of that, who are conversant in multiple languages, are conversant in civil law and common law, and who are conversant in multiple cultures. Because ultimately, what investor-state dispute settlement is about is explaining your position to someone from, by definition, another country. So you need to have someone who is conversant, as I said, in all of those different languages.
Great. I think we have time for perhaps one more question that just came in. And the question is, let's see. So this is from a heavy industries company. I'll just leave it at that. And the question is diversity among arbitrators in commercial cases. And the question really goes to the lack of diversity, especially in seeing people based in Asia as the chair. So what is the ICC, KCAB, or ANP law firms are doing to ensure that there's more diversity essentially in tribunals, and especially the chair or presiding arbitrator. I can take a crack at this one and invite others to join as well. I was served on the HKIC council for about 6 years and headed the appointments committee, and I know that HKIC was very serious about expanding diversity, gender, ethnicity, nationality, and age in terms of its appointment process. So I do think that in many institutions, and I certainly invite Maria for the ICC's perspective to promote diversity. But then again, one other thing to keep in mind is that the chair is a different issue with the sole arbitrator, but as far as party appointed arbitrators, that's an area in which I think the comment here rightly points out that law firms and parties can play an important role. And I do think a lot of law firms are doing that. But then there's also the concern whether the client will approve of someone who might be a very good arbitration lawyer, but less experienced for the exact reasons that you've noted. And perhaps they are younger, or perhaps they're not from sort of a more traditional European arbitration country and whatnot. So that's also, I think, an area in-house counsels can play a very important role, not only in the actual cases that they're working with, but I know that institutions, including KCAB, are very mindful of the views of the users. So that's also an area in which in-house counsels, I think, can play an important role. Maria, perhaps you'd like to talk about the ICC's view on this, or your experience there?
Yes, thank you, JH. I can tell you that the ICC is firmly committed to training and developing a more diverse pool of arbitrators. And I see this just from the number of appointments that are given to first timers, smaller cases, so that they can develop their skills and ultimately be in a position to serve as chair. But we can also see the ICC's commitment to diversity in the initiative to achieve gender parity on the ICC court. This is something that happened just right at the time that I started my first term about 4 years ago. This in itself helps to develop diversity, because by sitting as a member of the court, you obtain insight and training into the most difficult issues that are presented in arbitration and the most current issues. So I think the ICC has certainly made clear that commitment, but I don't think the ICC is alone. I think other institutions also have undertaken various initiatives. And I think this past year in particular, we've seen multiple initiatives that have been put in place even by individuals not having any involvement with institutions, because this has become really such a pressing issue. So there's a lot more work to be done, but we are making some progress, I would say. Thank you.
Great, thank you, Maria. I think with that, we are out of time. We've gone a bit over, and I know it's certainly getting very, very late in DC and San Francisco. So we will close with that. If the audience has any additional questions about some of the cases we mentioned or some of the issues, you're very welcome to email us, and we'd be happy to respond via email or otherwise. So again, we would like to thank the KCAB for organizing the event. Certainly, I thank all of my colleagues who have joined today, and we thank the audience for joining, and we hope this was a helpful discussion. Thank you very much.
Thank you, everyone.
Thank you.
Bye.